Sa ngayon, hindi na yung Rome Statute kasi post-2019 na tayo, no? So, ang huling kataga, pursuant to the applicable extradition laws and treaties. It's very clear, it's the last sentence of Article 17. And in an interview, the former Supreme Court Justice Adolfo Azcuna opined that surrender must be made pursuant to an applicable treaty. And since the Philippines is no longer a party to the Rome Statute, what then is the applicable treaty? Wala nang treaty. Dahil ang ini-invoke nga yung Rome Statute, wala na ngayon. Siguro si Justice Azcuna mas mahusay magpaliwanag.
Thank you very much, Madam Chair. Regarding the applicable provisions, the justification given by government for the surrender of former President Rodrigo Duterte to the ICC consists of two grounds. One is the warrant of arrest issued by the ICC and served through the protocol of the Interpol. The other is Section 17 of Republic Act 9851, which is the Philippine IHL law, and which provides that if a person is already being investigated for the crimes covered by this act, which includes crimes against, which includes the crimes for which President Duterte is being charged, is already being investigated by an international tribunal. The relevant Philippine authorities may surrender such person to the international tribunal, but it adds pursuant to the applicable extradition laws and treaties. Ngayon, ang tanong, ito bang last sentence na ito, which provides for the requirement that the surrender should be pursuant to applicable treaties, is still applicable since we don't have anymore the Rome Statute. Sa palagay ko po ay it's either we have the Rome Statute or not. If we don't have a treaty, then we cannot surrender the suspect to the ICC under this section, because this section requires that the surrender be pursuant to a treaty. Pursuant means in accordance with. And so if there is no treaty, in my view, we cannot make a surrender. On the other hand, if there is still a treaty that is due to the residual obligations that the Philippines may have even after withdrawal, pursuant to Article 127, Paragraph 2 of the Rome Statute, after withdrawal, the withdrawing state still obliged to cooperate with the ICC in relation to matters already under consideration by the court prior to withdrawal. So again, you go back to the question, is the Philippine situation something already under consideration by the court, by the ICC, prior to our withdrawal? In my view, Madam Chair, the answer is yes, because as of February 8, 2018, prior to our withdrawal, Fatu Bensouda, the former ICC prosecutor, already said that the Philippine situation is under preliminary examination as of that date. The question is whether or not the prosecutor is the court, because 127 paragraph 2 says under consideration by the court. And in my view, it is, because there are four principal organs of the ICC. The first is the presidencies. There's one president and two vice presidents. The second are the judicial divisions. The third is the office of the prosecutor. And the fourth is the registrar. So the office of the prosecutor is part of the court. Therefore, when Article 127, paragraph 2 says, the matter must be under consideration by the court at the time before withdrawal, it includes consideration by the prosecutor. And so therefore, I believe we have residual obligations even after withdrawal. Question therefore is whether or not the warrant of arrest issued by the ICC after our withdrawal is something we have to cooperate with. Under 127 paragraph 2, in my view, yes. And therefore, in my view, the warrant of arrest is legal. However, I believe that the surrender is not, because the surrender must be pursuant to a treaty, and therefore our own law, Section 17 of Republic Act 9851, brought back the Statute of Rome, even after withdrawal, because it requires that a surrender must be pursuant to the applicable treaty. And therefore, in this case, the applicable treaty remains the Statute of Rome. And thus, we have to follow Article 59 of the Statute of Rome, which requires that the custodial state, namely the Philippines, must first bring the arrested person to a local court to determine two things: whether or not the person is really the one named in the warrant. Second, whether or not the person has been informed of the charges against him or her. This was not done. Therefore, there was, in my view, a violation in the act of surrender. However, Madam Chair, this is in the forum of the Philippines, but in the forum of the ICC, different rules apply. The rule in international law, Madam Chair, is that procedural laws are governed by the forum. So procedural safeguards are applicable only to the forum. If the Philippine Bill of Rights, for instance, which says that no person however, criminal proceedings before the ICC is governed by their own procedure. This is in accordance with private international law, that procedures governed by Lex Fori, the law of the forum. And therefore, we go to the procedure in the ICC. In the ICC, I believe they follow what is called mali coptus beni detentus, meaning that even if the arrest is illegal, the detention can be legal. It does not automatically mean that if the arrest was illegal, the person arrested must be released. They will balance, it's a balancing act. They will balance the illegality of the arrest with the need to prosecute someone for very serious offenses under international law. And in their view, the balance weighs in favor of prosecution. They will prosecute, notwithstanding the violation of the procedure in the arrest and in the surrender, I mean. Therefore, it depends on whether you're talking about Philippine Forum or the ICC. The ICC, I believe, will follow their own procedure, whereas in the Philippines, as it is now pending in the Philippine Supreme Court, in my view, there is a violation and there will be consequences for that violation. Thank you, Madam Chair.
Thank you very much, Justice Azcuna. As usual, we received a very exhaustive opinion, and I'm certain that we will be guided by the same. I think Senator Cayetano would like to respond.
May I take advantage of the knowledge, wisdom, experience of Justice Azcuna, not only as a former Supreme Court justice, a recognized legal luminary, but as a member of the Constitutional Commission. Sir, can I take a step back? When the Constitutional Commission discussed the Bill of Rights, and in Section 2, the rights of the people to be secure in their persons, houses, papers, effects, against unreasonable searches and seizures of what nature and for any purpose shall be inviolable, and no search warrant or warrant arrest shall issue except upon 1, probable cause, 2, be determined personally by the judge after examination under oath of affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the person or things to be seized. Am I correct, sir, that this was also a reaction to a period in the martial law where there were different kinds of warrant of arrest? Diba yung, I don't know the name of all of them, but ASO, so there were arrest warrants from many sources, including the military. So the commission, in its actions as representing the Filipino people, so fit. At least ito po yung tinuro sa amin sa Ateneo Law, that ang pinaghugutan nito, to be sure that if someone is arrested and it's not on a whim, it's not politicizing whatever, we will make sure by one, judge lang ang pwede sa Pilipinas ang mag-issue ng warrant. Of course, the Supreme Court has already said may exception like the Bureau of Immigration just for the foreigners. But in general po, it has to be a judge. He can only issue it upon personally determining that there is probable cause after examination under oath of the complainant. Am I generally correct, Mr. Justice?
That is correct, Mr. Senator.
Yeah. So that is why in our 14 treaties for extradition with other countries, pare-pareho yung procedure that after the DFA receives the request for extradition, pupunta muna to sa isa nating judge. Para yung judge pa rin ang titingin. Am I correct? Am I wrong? SOJ, tama, no? So that the judge can double check and then he will be the one to either confirm or verify or issue the warrant of arrest. Then yun ang isa-serve ng local police. That's my understanding.
That is correct, Mr. Senator. The need for a judge to be the one issuing the order in cases of warrant of arrest and even search warrant is enshrined in our Constitution, because there were previous occasions prior to our adoption of our Constitution where instead of a judge, it just says an authorized officer. So it has to be a judge. In the case, however, of the ICC, the warrant of arrest was also issued by a judge. In fact, 3 judges issued the warrant of arrest under the ICC. Question is whether or not that warrant of arrest can be executed in the Philippines by Philippine authorities. And that is, I think, pending the Supreme Court now. There are pros and cons on that, but one issue there is whether or not the 3 judges pre-trial chamber of the ICC acted on probable cause or merely on sufficiency of evidence.
Yes.
But as I said, the provision on probable cause and the judges issuing the warrant are procedural safeguards that are good only for the forum and not applicable abroad. That is the limitation. Our Constitution does not extend beyond our territory. Thank you.
Point I was going to, sir, is really the legal remedy of a Filipino citizen to run to our judiciary, which I ask Attorney Alexis Medina and go to him later. But my point, I think you already read my mind, Mr. Justice, and because you were saying we are not sure whether the judges or justices of the ICC went into probable cause or sufficiency, because we are also not sure if they issued the warrant based on a personal determination of the witnesses or complainants under oath. We do not know whether these are media reports or whether their prosecutors came here and interviewed them, no? So ang point ko, Mr. Justice, if I was being arrested and I'm not sure, I should be able to go to Philippine courts. Sa extradition treaty, sir, judge din naman judge ng US, judge ng UK ang nag-i-issue nito, no? And I checked with the ICC versus the other countries that signed with them. For example, the United Kingdom, no? It is the appropriate judicial officer who will issue the warrant of arrest of the UK. So from ICC, ido-double check pa rin ng ano. Ganon din po sa Canada. The Attorney General will apply ex parte for a provisional arrest before a judge. So it's not the fiscals, it's not the Prosecutor General. The Prosecutor General's job there is to bring it before a judge. Ganon din po sa South Korea, ganon din po sa Argentina, ganon din sa Paraguay at South Africa. That is why if we look at the information of surrender and transfer sa page 8 po, number 8, sorry, not page 8, number 8. Nakalagay po dito, the date, time, and location of the appearance of the arrested person before the competent national judicial authority. Ang sagot po dito na ang pumirma, if I'm not mistaken, si Ambassador Lacanilao, do not know. So he did not know when he surrendered the former president whether they were brought before a judicial entity. So yun po yung main issue ko, Justice, na ang pagkaintindi ko, kung meron pong dispute sa interpretation ng batas or even sa issue of application of the law to certain facts, a Filipino citizen at any time can run to a Philippine court. But in this case kasi, he was denied the opportunity to run before a Philippine court because he was put on a plane and sent there, no? So even assuming I agree with everything you said now and I see the legal basis naman nung sinasabi nyo, sa akin, that remains to be the question on my mind. Can we deny a Philippine citizen the opportunity to go before a Philippine court? According to General Torre, and he can rebut this later on, is that 8 or 12 hours is enough, di ba? But I think mas malaking issue yon kung ang court nag-issue ng TRO within 8 or 12 hours unless the circumstance. I think at the time na the lawyers applied, hindi nga nila alam na isasakay sa eroplano di ba? But I leave it there. Feel free to comment, Justice. Ang point ko lang po, I think the spirit and letter of the Constitution is clear. It has to be before a Philippine judge to determine this, no?
In fact, Mr. Senator, the procedure in the ICC calls for bringing the person to a Philippine court first before surrendering the person to the ICC. So if you do not follow that, it can be argued that there is what they call abuse of process, and an abuse of process can be raised in the ICC itself. I think this is what will be considered in the September hearing scheduled by the pretrial chamber. Under the rules, objections to the legality or objections on abuse of process may be raised and resolved by the pretrial chamber, probably at the scheduled September hearing. So this remains still open, even in the ICC. The question of the validity of the surrender in view of the non-observance of Article 59 of the Statute of Rome itself. And the other thing is whether or not such abuse of process is curable. And again, that is debatable. It seems to me that the initial hearing on March 14th done by the pretrial chamber was an attempt to cure the deficiency of the absence of Article 59 procedure, because the three judges of the pretrial chamber in that hearing simply did what a local court would have done. That is, determined that the person is the same person named in the warrant of arrest, and that the person was informed of the charges against him or her. And after that, they said session adjourned. So they merely supply the defect that the absence of the custodial state's local court created. So it remains whether or not male captus bene detentus will be applied by the ICC.
Yes.
Thank you.
Mr. Justice, yung dahilan kung bakit yun ang tanong ko, no, the reason for my questions is, I grew up dun sa naririnig mong sa presinto ka na lang magpaliwanag. And after the EDSA revolution, eto sa bagong constitution, then the many laws we passed after addressed that. Hindi pwedeng bigla ka na lang hulihin tapos sa presinto ka na lang magpaliwanag. Unfortunately, parang yun ang lumabas, sa Hague ka na lang magpaliwanag. Even if there are defects here. But I just like to express my admiration, the way you explain very fatherly, whether it's in class, it's in the Supreme Court oral arguments, or here. Thank you for your calming voice during these confusing times. Thank you, Madam Chair.
Huling hirit po, Justice, may binanggit kayo ng mga violations locally, and such violations would inevitably incur consequences. What possible violations are there to local law and our Constitution?
The possible violation, Madam Chair, consists in the surrender without passing through the court, what we call extrajudicial rendition. That issue will have to be resolved by the Supreme Court, whether or not an extrajudicial rendition is valid in the Philippines in view of our Constitution. And the other issue is whether or not there is a comma that separates international tribunal from another country. In other words, whether or not the colatilla, subject or pursuant to the applicable extradition laws and treaties, refers only to extradition and does not refer to rendition because of comma. I look at the text of Republic Act 9851, Madam Chair. Section 17 does not have a single comma. It has two commas. And the two commas are parenthetical commas. They are not separating commas. They are parenthetical because they merely enclose the words "if any." So it says that the Philippine authorities may surrender the suspect to the International Tribunal, comma, if any, comma, or to another country pursuant to the applicable laws, extradition laws and treaties. So the commas really refer only to if any. It is not meant to separate the provision that requires a treaty from surrender to an international court, in my view. So it's not a single comma. Dalawa pong comma yan. Ang function ng dalawang comma in grammar is like a parenthesis. If any, because the words if any. So to me, the violation is not doing the rendition pursuant to the applicable treaty. The applicable treaty is the Rome Statute. It is brought back into application by our own Section 17 if you do a rendition. So if you do a rendition, you have to follow the procedure for rendition in the Article 59 of the Statute of Rome.
Yes, thank you very much, Justice. And certainly, looking at the transcripts as well as the original bills filed, maliwanag po na talagang walang comma. So, ibig sabihin, pareho yung extradition tsaka surrender na kinakailangan may treaty o batas na pinagbasehan. Maliwanag po yun, kaya't aabangan natin yung hatol ng ating Korte Suprema. Maraming salamat po. Thank you very much.